Hello, my name is Anastasia Del Carpio. I am an immigration attorney with Lutheran Family Services Rocky Mountains. I am here today to give you some general information about the naturalization process. I'm going to talk about the eligibility requirements, the process of applying, and then the importance of going to an immigration attorney or DOJ accredited representative if you have questions and need help with the naturalization process. Remember that today's presentation is legal information, but it is not legal advice. If you need legal advice, please make an appointment with an immigration attorney or DOJ accredited representative so that they can give you information about your specific situation. First, let's talk about the eligibility requirements for naturalization. Remember that naturalization is the process of a lawful permanent resident becoming a U.S. citizen. And the eligibility requirements are what you have to prove to immigration for them to grant your naturalization application. First, you must show that you are at least 18 years old or older. You also must show that you're a lawful permanent resident, that you have a green card. You have to have had your green card for the required number of years. For most people, that's 5 years. If you are not sure when your permanent residence began, you can look at your green card. At the bottom, it says resident since, and it has a date. That's the start of your lawful permanent residence. Now, there are some exceptions. There are some people who can apply before 5 years. One example is individuals who are married to a U.S. citizen. If you can show immigration that you're married to a U.S. citizen, that you've been living together in marital union for at least 3 years while you had your green card, you are allowed to apply early after only 3 years of lawful permanent residence. Another example is our refugees and asylees. Their green cards are backdated. So a refugee's green card is going to be backdated to the date they entered the United States as a refugee. And our asylees' green cards will be backdated to 1 year before their green card was actually granted. Again, if you're not sure when your 5-year period began, you can look at your green card at the resident since date, and it will show you the start of your permanent residence. Your permanent residence also must be continuous, which means it cannot be broken. This is the first way that immigration is going to look at your travel outside of the United States. If you have any trips inside your 5-year look-back period where you were outside of the United States for 6 months or less, that trip will not be a problem for your continuous residence requirement. However, if you have any trips where you were outside the United States for more than 6 months during your 5-year look-back period, that will impact your eligibility for naturalization. So if you have any trips inside your 5-year look-back period where you were outside the United States for more than 6 months, you should speak to an immigration attorney or DOJ accredited representative before you file for naturalization. They can help you understand if you are still eligible for naturalization right now, and if so, what additional documents you need to send with your application. It's also important to talk to an immigration attorney or DOJ accredited representative before filing for naturalization if you have long trips that are more than 6 months outside of the United States, because those trips could trigger questions from immigration about whether you abandon your lawful permanent residence. Abandonment is where you move to another country after you become a permanent resident. Abandonment is a deportability issue, meaning it is not just a problem for naturalization, it is also a problem for your green card and your right to remain in the United States. So if you have any trips that might look like you moved to another country after you got your green card, you should speak with an immigration attorney or a DOJ accredited representative before you file for naturalization. You also need to show immigration that you are a person of good moral character. Good moral character is a very complex requirement, and there's no way for me to explain everything about good moral character in this short video. The easiest way for me to help you understand what immigration is looking at when they look at good moral character is to talk about the yes and no questions that are on the naturalization application, the Form N-400. Those yes and no questions cover all sorts of things like filing taxes, contact with law enforcement, your immigration history. They cover your entire life from birth until now in any country in the world. If you think that you need to answer yes to one of the yes and no questions, or if you are not sure whether you need to answer yes to one of the yes and no questions, that is a legal question, and you should see an immigration attorney or a DOJ accredited representative before you file for naturalization. It's important to talk to the attorney or the DOJ accredited representative before you file, because some yes answers can also be deportability issues. Remember that a deportability issue is a problem that once immigration knows about it, it can impact not just your naturalization application, but it can cause immigration to try and take away your green card and make you leave the United States. An immigration attorney or DOJ accredited representative can help you understand, do you need to answer yes to the question? If you do, does it impact your naturalization application? And does it trigger any deportability issues? You also will have to show immigration that you're able to pass the English reading, writing, and speaking tests. You will have to pass the civics test to show your knowledge of U.S. history and government. And you will have to show that you understand and are willing to take the oath of allegiance to the United States. Next, let's talk about the process of applying for naturalization. There is a filing fee, which is money that you have to send with your application to immigration. Most people have to pay that filing fee with their application. You can find the current amount of the naturalization filing fee at the uscis.gov website. Now, there are two fee waiver applications. One is a complete fee waiver so that you would not have to send any money with your application. The other is a half fee waiver so that you only have to send half of the fee with your application. You do have to qualify for those fee waivers, and if you do qualify, you have to send a second application, a fee waiver application, with your naturalization application. You can find the fee waiver forms on the uscis.gov website. If you have any questions or problems with the fee waiver forms, an immigration attorney or a DOJ accredited representative can help you complete those applications. If you need help with the naturalization application, or if you have questions about the naturalization application, it's important that you get that help from an immigration attorney or a DOJ accredited representative. Remember that the wrong legal advice can hurt you. It can hurt not just your citizenship application, it can also hurt your green card and your right to stay in the United States in some situations. So it's very important that if you need help with the form or you have questions about the form and how to fill it out, that you get that help from an attorney or a DOJ accredited representative. I've included links at the end of this video where you can find an immigration attorney or a DOJ accredited representative. And remember that there are nonprofits like Lutheran Family Services Rocky Mountains with attorneys who can help you for a very low or no fee. Finally, I want to make a note about marijuana. Remember that marijuana is illegal under federal law, and immigration is a federal agency that uses federal law. So even in states like Colorado, where state law says that some people can use or sell or grow or work in marijuana, it is still not safe for anyone who is not a U.S. citizen to be involved with marijuana in any way. Being involved with marijuana before you become a U.S. citizen can have serious immigration consequences, like denial of your naturalization application, and in some cases, it can make you deportable from the United States, putting your green card and your right to stay in the United States at risk. If you have any questions about marijuana, you should speak to an immigration attorney. Thank you for being with us today. There are resources at the end of this video, like the uscis.gov website, where you can find instructions, free forms, and more information about the naturalization process.